Friends, welcome once again. Today I am again before you talking about a very innocuous topic as to what should be the approach of a government servant who has been served with the charge sheet, whether under Rule 14 or under Rule 16 of the CCA Rules 1965. Friends, general experience has been that when the charge sheet has been served on the government servant, he starts approaching certain senior officers, certain corners, and taking their advice what should be done with the charge sheet, with the pious hope that he might influence the disciplinary authority for dropping the charge sheet. Friends, in 99.99% of the cases, it does not happen. When the charge sheet has been issued, the cat is already out. The damage is already done, and it is almost impossible for you to get it managed, to get it dropped at the initial stage without facing the ordeals of the inquiry. In such circumstances, the moot question which arises in the minds of the government servant, what should be the approach? In that context, my suggestion to all of you would be kindly face it, because when the inquiry has been ordered, when you have no choice but to face it bravely, face it strategically, face it with all the defense available at your command. It is in that context that the rule requires, before the inquiry officer is appointed to undertake the inquiry proceedings, or the presenting officer has been appointed for representing the case of the disciplinary authority, the rule requires filing of the written statement of defense. For the purpose of filing of the written statement of defense, my advice to you would be kindly go through the documents which are listed in Annexure 3 of the charge memo carefully. If the documents have not been supplied with the charge memo, my advice to all of you would be kindly insist the disciplinary authority to supply the copies of the documents which have been replied, which have been mentioned in Annexure 3. Along with that, my advice to you would be to request the disciplinary authority to allow inspection, whether the original of the documents which have been referred in Annexure 3, they are at all there, they are in existence or not. It is very important for you. My suggestion to you would be go through those documents. And lastly, my advice to you would be, the moment you have been served with the charge sheet, whether for major penalty or for manual proceeding, kindly consult the competent advisor around you. Competent advisor would be, in most of the cases, a senior officer who has the knowledge of the rules and the procedures to help you. His advice might result in preparation of the written statement of defense in such a way which might, it is quite possible, convince the disciplinary authority, oh, this is not a viable exercise to undertake the inquiry, and let us take a call, and it is quite possible that proceedings might get dropped. So in short, my suggestion to you all would be, instead of hobnobbing around the senior officer so as to get it managed that the procedure get dropped, my advice to you would be face it like a brave man. And I am quite sure if you face those charges which are made out in the charge memo bravely, strategically, it is quite possible you might ultimately get relief in the inquiry or maybe even afterward. And second alternative would be, if you feel the charge sheet has been issued without any rhymes and reasons, without any justification. Third stage would be to approach the court of law at the initial stage. And in that context, my advice to you would be, it is better to approach the court of law than to approach certain senior officers in the department or outside the department to get it managed, because the court of law will ensure the final relief to you. And because the mind of the decision is already made, that your conduct is having certain prima facie element in that. So this is what I wanted to advise you today, and my advice to you would be that face it bravely. If you like the presentation, kindly share it with all other concerned for their benefit. Thank you.